Good afternoon, and welcome to the Carr Center for Human Rights Policy at the Harvard Kennedy School. I'm Sushma Raman, the Executive Director, and it's my privilege to welcome you to today's conversation with Rachel Lopez, Ghani Kempis Songster, and Andrew Crespo regarding redeeming justice. I was stunned to find out that the United States is the only country in the world to have juvenile life without parole. And as I read the article written by Terrell Carter, Rachel Lopez, and Kempis Songster, I was really moved to really think more closely about the broader themes of justice and redemption and how to realize them in today's world. So I'm going to turn it over to Rachel and Kempis for a PowerPoint presentation. We'll then hear a reflection from my colleague at Harvard Law School, Andrew, and then we will open it up to your questions as well as questions that Andrew and I might have for them. Thank you so much.
Hello, everybody. Thank you so much for having us. I'm so grateful to Sushma, to Andrew, to Larissa, and especially to my co-author, Ghani, for being here today to share our article, Redeeming Justice. Ghani, will you introduce yourself as well?
Hello, everybody. My name is Kempis Songster. A lot of people call me Ghani. It's an honor and a blessing to be here beyond anything you can imagine. For me, I'm especially pleased to represent my friend, Terrell Carter, our co-author, who unfortunately can't be here with us. Hopefully soon, the rest of the world will get to know Terrell Carter in the way we know him and all the beauty that he is. I am program manager of Youth Art and Self-Empowerment Project's Restorative Justice Diversion program called Healing Futures. And again, it's an honor to be here.
I first met Ghani and Rel when my clinic partnered with a think tank that was mostly comprised of individuals who were sentenced to life without parole. My students and I learned from Ghani and Rel and so many of their colleagues about the power of redemption. And it became a rallying cry for us over the past few years. And it really birthed this article. That clinical work was the inspiration for Redeeming Justice, which essentially argues that all people have the capacity for change, and that this characteristic is so core to the human condition that all people should have a right to redemption. The group explicitly conceptualized the right as a human right and emphasized how the US criminal legal system denied that right.
In our piece, we argue that the right to redemption is an explicit human right, an inalienable human right, because everyone has the capacity for transformation and change. We argue that the denial of that right is an affront to the Eighth Amendment to the Constitution, which protects people against cruel and unusual punishment.
This article is meant to draw on a body of work that really emphasized the value of lived experience as evidence. It's in a long tradition of critical race theory and an emerging body of scholarship called movement law scholarship, which tries to develop legal meaning alongside social movements and really draw from those most affected by human rights violations to lift up a new legal reality for so many in our country. And I want to start off today by framing our discussion with a quote or a question that was raised by Justice Alito in oral argument for a case called Jones v. Mississippi. In Jones, the fundamental question was whether a court could sentence a juvenile to life without parole without a finding of permanent incorrigibility. Permanent incorrigibility means that those individuals essentially are incapable of redemption. They are deemed irredeemable. And the court posed the question of whether this was required in order to sentence a child essentially to life without parole. And at oral argument, Justice Alito raised the following question.
Good morning, Mr. Shapiro. If you have it in front of you, could you just repeat the first sentence of your presentation this morning? Yes, Your Honor. The first sentence was settled law recognizes the scientific, legal, and moral truth that most children, even those who commit grievous crimes, are capable of redemption. Yeah, I think you are. This is fascinating. You want to take us and you want us to take the courts of this country into very deep theological and psychological waters. Do you think that there are any human beings who are not capable of redemption? Good morning, Mr. Shapiro. Good morning, Mr. Shapiro. If you
Our co-author, Terrell Carter, answered Alito's question in this way.
Before I attempt to answer Alito's question whether or not there are people who are beyond redemption, I would like to first establish a preface. Preface being, as a member of Right to Redemption, I have to ground my answer in a couple of our basic principles. Number one, all human beings, barring a debilitating apathy, have a capacity to atone for their transgressions. And this characteristic is one of the things that distinguishes us from the other animals. Number two, because it is a uniquely human attribute, it falls into the category of an unalienable right. So to curtail, strip, or deny the right to exercise this capacity is a gross human rights violation. So, with that being said, mandatory death by incarceration sentences deny an individual's ability to exercise this capacity. This, as my good friend Ghani would say, procrastinating application of a law flies in the face of the founding principles of this country. DBI sentences inherently mean that a human being is bereft of the capacity to try and make right wrongs. But how is that possible if this ability is unalienable? It's only possible if we confuse capacity with the act. So let us, in having these discussions, be clear in the distinction between the two. All human beings have the capacity to redeem themselves, but all human beings may not exercise this ability. To not exercise it doesn't mean that one doesn't have it. The laws of the greatest democracy the world has ever known, if they are just laws, should simply reflect this. They should also always embody the words of one of the founding fathers and authors of the Declaration of Independence, Thomas Jefferson, who said that, quote, all men are created equal, that they are endowed by their Creator with certain unalienable rights, unquote. Jefferson understood that true freedom couldn't exist without the recognition and respect of what makes us human. To not recognize and respect these attributes is to invite oppression and abuse. So with that being said, human beings should never be separated from their capacity to make amends. So
This is a call from SCI, Phoenix State Correctional Institution. This call is subject to recording and monitoring.
So, to Alito's question, I say resoundingly that no human being is beyond redemption because we all, even in the worst situations, unequivocally have the capacity to atone. This, I believe, is the very essence of who we are as a species. And to truly understand and embody this principle, what allows, in the words of the United States Supreme Court, an evolving standard of decency that marks the progression of a maturing society.
So that's Terrell Carter, chairman of Right to Redemption, one of the founding members of the Coalition to Abolish Death by Incarceration, and several organizations and programs inside and outside of prison, graduate from Villanova University, published author of 3 books, father, grandfather, student, someone that works in hospice care, taking care of the elderly, someone who has mentored countless individuals, young people coming through the prison walls. Terrell Carter is a deeply reflective human being. I remember when we founded Right to Redemption together, he, myself, and several other men behind the walls, we wanted to approach the issue of life without parole from an entirely different perspective, right? We recognize that life without parole was a deeply problematic sentence, and that it had 5,400 people condemned to die in the prison system in Pennsylvania, 162,000 in the rest of the country, right? Serving a sentence that is not implemented this way in any other part of the world. We decided that we had to do something that pushed back against the notion that somehow we were not anything more than the worst thing that we ever did. But we approached it from a different perspective and from a different angle, not from a position of entitlement, not from a position of that we were owed something, but from a position of we have a lot to atone for, we have a lot to be responsible for in our communities, and to deny us the right to atone, to be accountable, right? To be more than the worst thing we've ever done is an affront to our humanity and our capacity for change.
And as I began to do research actually on behalf of the think tank, I learned that the R2R committee's understanding of the right to redemption was both articulated and reinforced by international human rights law. At the same time as the R2R committee was developing and growing its understanding of the right to redemption, the European Court of Human Rights was examining whether hope should be a vital aspect of the human person, such that life without parole sentences, which deny the capacity for change, should be considered inhumane and degrading. The Winter Court held essentially that all prisoners are entitled to release on the basis of rehabilitation, and that review should be regular throughout periodic times in the sentences, and that all sentences must be justified beyond the reason of retribution. And one part I found so incredibly moving was how the Winter Court, much like the R2R committee, understood sort of the blockage of atonement that happens with life without parole sentences as being akin to torture. They said, if a prisoner is incarcerated without any prospect of release, or without having the possibility of having his sentence reviewed, there's a risk that he can never atone for his offense. And this was reflected in countries, the same sentiment in my research I found was reflected in jurisdictions across the world, finding that such sentences that lacked such a possibility of review and release to be an affront to human dignity, and learned that only 38 of the 193 countries of the world even allow for LWOP sentences. And the United States has taken a decidedly different approach. It has taken a retributive approach, essentially by its own words, forswearing the rehabilitative ideal. Instead of reaffirming hope, it has denied hope, saying that good behavior and character improvement are immaterial. And this is the court's own words. It means that whatever the future may hold in store for the mind and for the spirit, the defendant will remain for the rest of his days in prison. It reflects an irrevocable judgment about a person's value and place in society. And this is why my co-author and his colleagues call such a sentence death by incarceration.
Connie, I think we need you to unmute yourself.
We realized very early in the founding of Right to Redemption that language was playing a very big part in the still waters that it seemed like the struggle for life against life without parole had been. Most of the support at the time on the outside was being marshaled for folks on death row, rightfully. That is an urgent situation. But we also found that a lot of the strongest proponents or advocates of life without parole as a more humane sentence were the opponents of the death penalty themselves. And it created a peculiar situation for us, because we did not want to, we saw opponents of the death penalty as our allies, and we didn't want to engage in an ideological struggle, certainly not a public ideological struggle with allies. We believe that the death penalty is inherently wrong, but that we, as people serving life without parole, didn't necessarily have to be thrown under the bus to make that point. That we could make that point about the death penalty on its face, but we didn't believe that we were offered up this way and that life without parole is being trumped as a more humane sentence out of, lack of care or malice on anyone's part. We believe that people were just not aware of how final life without parole is. That is just as final as the death penalty. The gravity of the sentence was hidden in the innocuous term life. The term life is really a beautiful term. It's a beautiful phenomenon. Who does not love life? And so to call something as so final and just as fatal as the death penalty, to call it life, it was also misleading, right? And it was inoculating the rest of society about how serious this and severe this sentence was. We had one sentence was death by injection or death by electrocution or whatever, sudden means, acute means of executing somebody, was employed. And then another is death by incarceration, which is a slow, regulated death, right? In fact, death by incarceration or life without parole was less escapable than the death penalty, because most of the support was for people on death row. People on death row had a greater chance of having their death sentences commuted and to life, right? Or receiving support to be released, than people serving life without parole. We were just not on anyone's radar. It wasn't a popular issue. In fact, most of the rest of society was thinking it's a more humane sentence, and so we found ourselves, just constantly behind the 8 ball, so to speak. And we decided that maybe we had to raise public consciousness by lifting up the gravity of the sentence, helping people to see how grave this sentence was. So we chose to call it what it actually is: death by incarceration. It's a jarring term, it shakes the consciousness, but it has shaken the consciousness about the sentence to life, to be awoke. And now an increasing number of people refer to the sentence as what it is. And we have been able to build solidarity, just around changing the language alone, that we haven't been able to do before.
And so in our article, we propose to take a redemptive reading to the 8th Amendment. we believe that affirming the truth that all people have the capacity for change and, in line with human rights law is possible through the Eighth Amendment. And in our article, we aim to bring about a human rights frame to the US constitutional understanding of cruel and unusual punishment. And we ground our theory, our argument within the latent concept of human dignity, which is, by the Supreme Court's own words, an underlying basic concept of the Eighth Amendment. We know through US Supreme Court jurisprudence that they frequently look to other jurisdictions' practices and laws to gain an understanding of what the Eighth Amendment means in this country. And thus we propose, similarly in line with past decisions like Roper, that the US Supreme Court and state courts around the nation intertwine understandings of human dignity worldwide, just like the other jurisdictions that I mentioned earlier, who understand life without parole sentences to be an affront to human dignity, that we too can embrace this understanding of the Eighth Amendment and of cruel and unusual punishment. So I'm discussing this from a legal perspective. You see on the slides how the US Supreme Court understands human dignity as a fundamental component of the Eighth Amendment. But if Ghani's comfortable, I'd like him to discuss this from a personal perspective, underscoring how a life without parole sentence felt, why it felt like an affront to human dignity to him and his colleagues.
Thank you so much, Rachel. So I'm aware that there might be a general and a wide indifference to how I or people who have done harm might feel about anything, much less how we feel about being told that we're irredeemable. I'm also aware that a lot of people out there might actually care how we feel. And for those who are caring, concerned, or just curious about what it's like to be treated like you're irredeemable, let's take a deeper look at that, right? Being told that I'm incapable of change, incapable of becoming better, or becoming anything more than what I was condemned to death by incarceration for, or receiving a sentence, a status, and a treatment that conveys to me that I'm permanently incorrigible, right? Irreparably corrupt or irretrievably depraved, right? And that I cannot be anything more than what I had done to warrant my condemnation, right? Didn't just seek to make me feel as if it might be true. It sought to make me and others similarly sentenced not even see the point of trying to be better, right? And how it makes us feel should be a cause of concern for our society, because how people feel and how they're made to feel, right, especially day in and day out of their lives, can translate into what they believe about themselves, which can in turn grow into how they behave, right? How they interact with the rest of their community. It could very well become what we call a self-fulfilling prophecy. Perhaps the most glaring examples of how dangerous negative feelings and self-perceptions could be seen in the violence we see ravaging our communities. It could be seen in the recidivism rates, or how people leaving prisons feel about themselves as they leave, right? Which a lot of times is worse than they went in feeling about themselves. So to push against all of that, we had to find a wherewithal to convince ourselves, right, every day that despite the state of condemnation that we were in, despite having a sentence that told us that we can't be better, right? And we had to dig deep to redefine ourselves, despite the fact that this bad thing that we did is the sum of who we are. That's what we're told. And this bad thing that we did is the sum of our destiny, right? We are more, right? Despite that, we're told that we're no good, and no good that we do matters, right? We do it anyway, because we come to realize that we are more. And it's one of the greatest demonstrations of the human potential to go against the grain, to defy the state's definition of us, and to do good. Even if nothing we do will avail us, right? We encourage others to do good, hoping it could avail them and avail the people in their lives or who cross their paths. And we can't bring that life back. We can't bring it back, but we can help save life. And believing that we have that capacity and that purpose is an achievement in itself. It shouldn't have to be difficult to be better. It should be facilitated. It should be supported on an institutional level, but it's one of the most difficult things to do when everything that controls your life says that you can't be better and it doesn't matter. So don't even try. And so we should definitely consider as a society the consequences of conveying to so many people in this country by condemning them that they have no redemptive quality even worth considering. And so, yes, I was squeezed between my own self-accusing spirit and the voice of the state, the media, society at large. I was squeezed between all of that, pounding me for years, condemning me for what I had done. But in all of that, there were some other faint voices telling me to not believe it, that you can be better, you are better. My own voice, the voice of the scriptures I was reading, my mentors in prison, my family and friends, I held on to those voices and they helped me preserve what little dignity I had left. And so, yeah, I felt the pain. I felt dehumanized. I felt helpless at times, but I found a wherewithal. I was encouraged to find a wherewithal in the things that I was reading, in the legacy of my ancestors, people all over the world that was suffering worse than me, and it was finding a way through to redeem themselves, right? And to redeem their life. And that's where we draw inspiration. It wasn't easy and it's not supported on an institutional level. We turn out the way we turn out, more socially responsible, ecologically responsible, not because of life without parole, but in spite of life without parole, in spite of death by incarceration.
And so Ghani, my co-author Rel, and I are proposing a path to redeeming justice, drawing both from the Right to Redemption Committee's fundamental principle of the right to redemption, but also drawing from human rights law to underline some basic principles about how life without parole sentences should be reviewed. And the first of these is this concept of legal certainty. We believe, and human rights law affirms, that those serving life sentences must know what they need to do to be considered for release. So our co-author Rel, who sits in SCI Phoenix and has no idea whether his, the lives that he's saved through hospice, or the lives that he's helped through hospice care, through the books that he's written, through the degrees, does any of that matter? There's no criteria for clemency, which is his only path to relief. And this is a violation of human rights. Second, we believe that all human beings must have a realistic possibility of release based on rehabilitation. This was affirmed in the case I mentioned, Vintner, and essentially means that in order for someone to be detained, in order for life without parole not to be a violation of human rights, individuals must have a realistic possibility of release. And that means that release can't just be released on the page, it has to be meaningful. People actually have to be released from prison on the basis of the rehabilitation. And finally, in accordance with human rights law, these reviews must be regular. So what human rights law holds under the progression principle is in essence that the state cannot indefinitely hold someone without justifying that denial and deprivation of liberty. That such deprivations must be reviewed regularly in order to ensure that they still hold weight, that they're still, the grounds on which someone is being detained still have purpose and meaning. And that's fundamentally demands that we make towards the path to redeeming justice.
And when we ask for parole eligibility for people sentenced to life without parole or death by incarceration, We're asking for a parole process that's in keeping and in harmony with human rights and what the rest of the global community calls for. A more humane parole process that has a level of certainty to it, like Rachel expressed. Nothing can be more dejecting than to spend years, doing the right thing, doing what has been asked of you and is required of you. And then when you get before the parole board, they tell you that they either don't believe you, that the reason why you're doing good is because you can just get out of jail, or whatever the reason may be, and then tell you come back and see them in a year or 2 years or 3 years or 4 years. And then this might happen repeatedly. And so we're asking for a parole process that's more in keeping with the international standards of human rights. And we're very clear of that, because it can be very indignifying and it can damage hope when there is no incentive, right? When there is no sort of like, not necessarily a guarantee, but at least, some type of certainty that, your transformation will be recognized, right? The idea of redemption for the Right to Redemption Committee, we explored redemption we thought that we weren't married to the term redemption per se, because the term had its own issues, being something defined as, a financial or economical arrangement, buying something back, and a lot of times associated with like a slave buying back their rights. And as majority African-American men behind the walls, you could understand why, we weren't too keen on the idea of using something that meant, buying ourselves back from slavery, even though, a lot of comparisons have been made, with mass incarceration or mass human caging and slavery. Redemption, we wanted to use it in a way that represented something a little more substantive and had a moral component to it. We started searching all around the world, reading about the different global concepts of transformation and change and redemption, whether it was the Judaic concept of galut, being exiled and condemned, and geula, being returned to the community, or the Christian concept of expiation of sins and meditation and reading of liturgy and sacrifice and service, or the Islamic concept of sacrifice and giving alms and praying and fasting, or the Hindu concept of, regaining or becoming what you were born to be, right? And delivering yourselves from psychological oppressions and internal sins. There was something common in all of these things and in all of these global communities, that human beings had the capacity to become better. We had the capacity to be more than our lower selves and the worst things we ever did. And more than that, redemption is realized or fully realized when we are in the embrace of the community once again, right? I remember I was given a prayer by a friend that I had made at a Yom Kippur service in Central Synagogue, New York City, after I was released from prison. And this prayer was called a redemption prayer, and it burned itself into my memory. And the prayer went as such, and it's called the prayer of redemption, or the redemption prayer. And it says, remember the day you witnessed the impossible. You once lived in chains, beaten by failure or sorrow, your feet sunk in mortar and mud. Then one day, a strong hand gripped yours and pulled you free. You once lived in a prison house, married to your master, afraid at every turn. And then one night, a pillar of fire ignited inside you, leading the way out. You once lay bound in a knot of grief, tied tight to a person that could never return, chained to a cloud. Then one day, you noticed that the cloud had moved behind you, urging you forward, and you turned to face the wind. You once lived in another city, in another country, in a place without choices, until you chose to be free. You carried all you owned on your shoulders and ran for the water's edge, and walls of water rose on your right and on your left. You were convinced that nothing would change. You were convinced that it would never happen, that your despair would overtake you and drive you into the sea. Then one day, today, you held your breath and decided to leap forward. And the waters parted and your feet found dry land. We were redeemed from slavery. Help us now to embrace our responsibility to redeem others. Inspire us to do our parts in creating a world that is filled with truth, dignity, and justice. And from that prayer, it really dawned on me that redemption is a collective process, that redemption is not just for people serving death by incarceration or the condemned. Redemption is also for those who condemn. Redemption is not just for the 2.5 million people behind prison walls, but redemption is for all 330 million of us who identify with systems of justice that rob people of humanity. Redemption is for all of us, our community, because only when we come together and take responsibility for everything that's going on in our community, only then can the healing begin and the redeeming of our society begins.
Thank you, Ghani and Rachel. This was so powerful. I'm going to turn it over to Andrew now to reflect and respond to the presentation, and then we'll open it up to Q&A, including from the audience.
Thank you so much, Sushma. My name is Andrew Crespo. As Sushma mentioned at the beginning, I teach at Harvard Law School, where with my colleague Premal Daria, I direct the Institute to End Mass Incarceration. And I just wanted to start by thanking Rachel and Ghani for inviting me to be here in conversation with both of you. And even more so than that, to thank you for writing this piece. I'm not sure how many of the folks watching have yet read this paper, but you should. I can't recommend it highly enough, the article that their talk is based on. I think the whole paper will be of interest to a wide audience, but part one in particular is just beautifully written and is accessible to folks who are not lawyers and are not academics. You can tell in reading it that it's written in the braided voice of Rachel and Ghani and Rel, their co-author. And it offers this discussion of the relationship between redemption and acceptance of responsibility and systemic injustice that is rich and nuanced and complex and thoughtful and eloquent. And I wanted to just lift up a piece from the article itself. This is sort of paraphrased a bit. I've sort of got some ellipses in there, but I'm just going to read it for folks watching. It says, "We were tainted by an adversarial system of quote unquote justice that made accepting responsibility and trying to make amends feel like a liability. Winning becomes the sole objective. At the moment of arrest, we became players in a game of life or death. To win meant living, getting our lives back, while to lose meant hopelessness and death. The process was so highly competitive that there was no space for nuance, regret, reconciliation, or healing. It was either guilt or innocence, death or life. You either lost or you won. As we grappled with the pain of what we had lost, it didn't take us long to realize that the game was rigged stacked against us, compromised by racism and poverty. The pernicious, deliberate indifference to fairness and equality was so all-consuming that it made it hard for us to see ourselves and the parts we played in these human tragedies. We were so consumed by these justified feelings of injustice that we were blinded to the wrong we had done. I read this passage and, immediately saw myself wanting to assign it to every student that I have. There's this powerful suggestion here, I think, echoing the philosophy of restorative justice that I know Ghani knows well. The suggestion is that our basic approach, our default approach to assigning criminal responsibility in the United States through the competitive adversarial process is in many ways at deep cross purposes with a set of values that everyone touched by harm or violence might want to see promoted instead of frustrated. Values like healing, like closure, like atonement, and yes, redemption. There's a line tucked into a footnote of the article that I thought was particularly moving here. They say, "We contend that it is possible to recognize, as we profoundly do, that the criminal legal system is often racist and fundamentally flawed, while at the same time to wish that we were not shedders of anyone's blood. We must hold space for this complexity too." The piece is especially powerful when Ghani and Rel each share and in the course of sharing really show how they came each personally to seek and to find redemption as they define it. They share through their stories, through their lives, compelling proof of the article's central premise. That, quote, "the capacity for change is core to the human condition and all people should have a basic human right to pursue personal redemption." As that last sentence shows, and as their talk powerfully demonstrated, the piece is more than an argument that all people can change. That, to quote Brian Stevenson, as Ghani paraphrased him, that we each are and that we can each grow beyond the worst thing we've ever done. It's also an argument about how the state, and specifically the law and the institutions of punishment in this country, ought to take account of this intrinsic human capacity to seek and attain redemption. And relatedly, but differently, it offers a strategy for how to get the state, how to get those institutions of punishment to change so that they do, in fact, acknowledge this core human capacity, at a minimum, by eliminating death by incarceration sentences. These two components of the paper, its argument about the state's obligations and its proposed strategy for how to get the state to change its current approach, made me have three reflections that I think are also, in a sense, questions for the two of you that I'll share in case they prompt more reflections from you that you can share with all of us about this really, really great piece of work. So the first is, I would love to hear you say more about the role that you think the state, the government, plays in an individual's process of atonement and redemption. There's a point in the paper where you're quoting a line from that Vintner opinion that Rachel mentioned, the opinion from the European Court of Human Rights, that says that if a person, quote, is incarcerated without any prospect of release, there is the risk that he can never atone for his offense. The suggestion here, I think, is that an interminable sentence imposed by the state violates what you all have called the right to redemption, because such a sentence prevents a person from atoning or from achieving redemption. But there's other parts in the paper where you suggest that maybe the state actually doesn't have much of a say in whether a person can seek or attain redemption. You write, the path to redemption is a deeply personal one. Redemption, you say, is not something the state can give or take away. There's a part of the article that's written by Rel, and I think he puts this point most powerfully when writing from inside of prison. He says, quote, "The conversations of discovery and growth that I was a part of freed me from the absolute confinement of a death by incarceration sentence. It has liberated me in the sense that I was able to demolish the invisible walls that had imprisoned me within a game I could not win." There's this moving way to read what Rel's saying, or at least I read it as him saying that the work that he's done with right to redemption, while still serving his sentence, has helped him to achieve redemption, whether the state wants to acknowledge it or not. And that struck me as moving and deep and also complicated for the argument, because if it is possible to atone, to achieve redemption, at least to some degree, inside of prison, in fact, if redemption is, as you say, not something the state can give or take away, it sort of complicates the idea that the state is somehow violating a person's right to pursue redemption. I think really there's a more concrete way to put this and to frame it as a set of questions for you, which is, I would love to hear you share whether you think it's possible to seek and retain redemption from within prison. If so, in what way the death by incarceration sentence is violating a person's right to redemption. And really, my ulterior motive here is to ask you if what you're really arguing for is something bolder. If you're arguing that the state has more than an obligation to simply acknowledge the right to redemption, but that it has to take steps to maximize a person's prospects of redemption and to respond when someone has tried to seek redemption and to respond even more so when they've attained it. So, okay, that's reflection question one. The second is about the strategy for how to get to the change that you are so compellingly arguing for in the world. As you laid out in the piece and in your presentation, the strategy is grounded in the Eighth Amendment. The move or the intervention or the argument is that human rights law and basic concepts of dignity, as incorporated into the Eighth Amendment, should render these types of death by incarceration sentences unconstitutional. When I was reading the piece, there were sort of actually two different strategies that I saw tucked inside of it. And to me, at least, they're somewhat maybe in tension with each other. And I would love to just hear you reflect on this. Because there's one strategy that I read it and I saw it as the community organizer strategy. And I saw it when I was reading the parts where you describe R2R itself, the organization that Ghani and Rel founded. Because when I was reading those parts of the essay first, it was just so moving and inspiring to read about the work that you all had done. And I saw it as an organizing story. A group of people directly impacted by this injustice, people serving these sentences in prison, came together to form a collective community around a set of shared experiences and shared narratives. And in that collectivity, they found power grounded in their collective resources, their stories, their relationships to one another, their relationships to families and communities outside of prison. And then they started to try to think through ways to use that collective power to fight an injustice in the world, including by going out and getting engaged in actual politics on this. The mission statement from R2R included in the piece says that they set out to actually try to get the legislature and to get the state government to ban these sentences and to get the people of Pennsylvania behind them to put pressure to make this happen. That's the organizing strategy. There's a second strategy in the piece that is what I call the lawyer's strategy. And it's the strategy that's basically embraced in the article, right? Rather than organize collectives of people to try to build and grow and use their own power to force a change in the law, the lawyer's approach, as Rachel and I know well, is to sue somebody, right? To bring an argument, or more specifically, to try to persuade a specific set of people, in this case, 5 out of the 9 justices on the Supreme Court, to right the wrong. By finding a right, or by announcing a right, or by recognizing a right in the Eighth Amendment, that these sentences are unconstitutional. This is maybe a caricatured way to frame this as the organizer strategy, the lawyer strategy. But I do it that way just because it evokes this sort of long-standing discussion, debate maybe, going back to at least the civil rights movement, about a tension between organizing for change and litigating for change. And in that debate, lawyers don't always get a good rap. Well, again, as Rachel and I know, lawyers never get a good rap. But here, the thing that may be most important is the lawyers sometimes don't get a good rap from the people they are trying to help. Not because of what they're trying to do, but because of how they're trying to do it. It was reminding me of this quote that I'll read from Ron Chisholm, who's a community organizer, and who, in conversation with Bill Quigley, a lawyer and law professor, said, "Lawyers have killed off more groups by helping them than ever would have died if the lawyers had never showed up. Most organizations, when they come up with a problem, they turn it into an issue and then they get stumped and they call a lawyer. And in that, people tend to transfer their interest in the issue and the problem to the lawyer, to have the lawyer solve it. And this creates dependency." lawyers do not understand that the legal piece is only one tactic of organizing. It's not the goal. So I should confess that this is all on my mind because at the Institute to End Mass Incarceration, we're spending a lot of our time thinking about the relationship between organizing and lawyering, and got a group of students that are reading this passage from Bill Quigley's article right now this week. And it just made me prompt these last two questions to both of you. The first is whether you think there's a tension between an organizing approach to this, what I see as the right to redemption approach, the collective approach, and the lawyer's approach, which Chisholm might say is disempowering because it's asking the justices to fix it for us rather than demanding that it be fixed ourselves, and by leveraging our own power to force this sort of change. And then the related and narrower point is about the choice to pursue the litigation route now, right? Because when I read the piece, it's this really well-conceived argument grounded in dignity and international human rights law that when I read it, I thought, gosh, this is an argument that could actually persuade Anthony Kennedy to recognize this right. It's written almost like for him, right? Dignity and the international consensus. And I thought, that's really great. That's really persuasive. And then I thought, but he's not on the court anymore, right? And he's been replaced now by multiple justices who have a very different view, both of redemption and of international human rights law. So I guess if the first question was why litigate instead of organize, the second is why litigate now when the endpoint of that litigation is the current Supreme Court. And I'll just end by saying that I hope, as is clear from where I started, all of these suggestions come from this place and this reflection of just deep admiration for this project. And really the compelling sense that the world as you envision it, where this type of sentence doesn't exist, is the world we ought to have. And that you're inspiring people to move towards. So the questions are really about trying to be in conversation with you about how we get there.
Thank you so much, Andrew, for your really thoughtful reflections and feedback, both on the article, but also the broader project of redemption. I'm struck, as I've heard three of you, as I think about how change happens. Does it happen at the micro level or at the macro level? And as I read the paper and I thought about this sort of state-by-state analysis of clemency and paths to achieving change, I'm also thinking about the broader context, the historical context in which the criminal justice system is situated, the ways in which the systems, the laws, the policies are really legacies of the history of the United States, the legacy of enslavement, Jim Crow laws, and so on. And so I'm wondering also if you can address this issue of, do you tackle this issue by issue, state by state, or do you really think about this in this broader framework of attacking a system that really has deep historical roots beyond this issue of juvenile life without parole, and we've seen it in the 90s with this, the 3 strikes and other ways in which the system has been so punitive to so many. So given that we have such limited time, I'm going to turn to Ghani first to reflect back on any of either Andrew's questions or mine, or just your reflections, closing reflections, and then turn it over to Rachel before we wrap up.
Yeah, just thank you. And thank you, Andrew and Sushma, for your deep reflection. There's so much to mine just from what you offered in your reflections, and questions itself lie the very answers themselves. But with respect to the state's capacity to facilitate redemption, we say, no, that's not what we're saying at all. We're definitely saying, and there's no contradiction. There's no contradiction in the piece that it's the complexity that Rel speaks of, and as he so eloquently and characteristically lays out, that it was an adversarial process for sure, a game of winners and losers, the way our experience and through the criminal legal process was, although it wasn't a game at all, it was very serious, but it's what many of us had become used to. Violence itself is adversarial. Nothing is more adversarial than violence. And we had adversarial relationships in the streets that too many times were violent and irreconcilable, or at least we don't give ourselves time to learn how to reconcile and to resolve conflict in that way, and the brazenness and brashness of our youth. We're used to adversarial and even dangerous relationships, but we were coming to terms that we had an adversarial relationship with a system now, or rather a system had one with us. And our studies and new experiences and the observations that we had behind the wall showed us that the relationships had been and would be adversarial between us and the systems that controlled our life, whether we had trespassed against each other or not. It was the kind of people that we felt we were forced to become. You know, what started with an horrific act, or what resulted from what landed us in prison, was to become who we are, right? That's what we push back against, right? Many of us wanted to come clean. Nothing crushes you more than the weight of guilt and shame, especially, you know, after committing the ultimate trespass, right? Many of us want to lay that weight down, right, and come clean. But it's so consequential in the system. The very first words we hear when we're arrested is, anything you say can and will be used against you, right? And so, like Rel laid out in the piece, you know, our journey since our entry into the prison, to the system's doors, to the whole time that we're in prison, going through the appellate process, we're reinventing ourselves, right? To protect our own sanity, deal with our own shame, right? Never being given any tools, right? Or being given any avenues to facilitate reconciliation, accountability. And so we get caught up in the game. We might develop political consciousness, even become, you know, join religion and latch onto spirituality and anything to try to regain our humanity and moral rectitude with, right? But then there is this other part that we never learned how to reconcile, which was the wrong that we've done, right? And because it's so consequential to do so. And so we live half lives and, you know, split personalities, where we abhor violence, structural violence. When we develop our political analysis and our geopolitical analysis even, right, and look at violence happening around the world, we abhor that. But then we haven't yet come to terms with the role that we played in the narrative of violence, right? And so R2R was an opportunity for us as men who had that in common, right? And not all of us were guilty. Some of us were innocent. Some of us were serving death by incarceration sentences who didn't hurt anyone. They were innocent. I wasn't innocent, but I know people who were. And we came into this circle, into the privacy of our own circle, to address this issue of death by incarceration. Certainly it was an organizing project. We didn't have that language for it though, Andrew. We didn't say we're coming together to do an organizing project. We developed an analysis of social and economical conditions and stuff like that. We saw the influx of more and more of our community members, especially our young people, who represented the future of our communities, and not just the proverbial future, but the very real future, right? And we couldn't just sit by and watch things play out this way. So our services, our commitments, and the personal convictions to change our own selves, right, in our young people, in our communities, in our own situations, were born of that inner imperative to not just be free, but to be free to be accounted for in our communities' ongoing struggle to right itself from the many things that it was dealing with out there: rampant violence, poverty, gentrification, the whole nine. And knowing that many of us were actors in the destructive narrative playing out in our communities, we wanted to be front and center in the efforts for change. And so that was from an inner imperative. The state could not give us that. Redemption for us was not rehabilitation, which is why we push back against the idea of rehabilitation. Rehabilitation, in our view, was what the state did for you, or what, you know, you're put in prison to be rehabilitated, right? We didn't believe that the state could rehabilitate us. We rejected the notion that we had to be passive subjects in this narrative and just sit there to be rehabilitated, right? Because we knew that it was never going to happen. That redemption is something else. Redemption requires agency on our parts, right? Rightfully so, because we had a lot to atone for in our communities. And if we didn't do it for ourselves, it would never get done, because the very sentence we were given said that we could not become better, right? And so for us, redemption was both something that required our own agency. It was something that the state couldn't give us, but it doesn't mean that the state could not obstruct it, because definitely the state, we looked at the state as obstructing the ultimate manifestation of redemption, because as social creatures, redemption can only be gauged or measured by how the community accepts our transformation, right? How the community receives, and it's about getting back into the good graces of the community, whether it's with the Christian concept of redemption, the Jewish concept of redemption with galut, the actual exile from the community, and geula, being brought back into the community, the Islamic concept, the Hindu concept, all throughout any, whether it's in the scriptures or any concept or understanding of redemption, from the prodigal son to whatever you want to think about, it's the idea of being brought back into the good graces of the community. That's what meant more to us than anything. Now, many of us have died in prison. We have friends who've gone on to earn their PhDs, who've founded programs, who've sacrificed, who've worked in hospice care, who've mentored, who've started foundations on the outside, but they have died in prison. They've died alone in their cells, right? Their sacrifices, their transformations didn't avail them anything, right? And so at least they're able to die knowing within themselves, and the rest of us who know them and love them behind the prison walls know that this person right here is not who the system said he was. But the ultimate achievement of redemption, or the culmination of redemption, or the actualization of redemption, is when you re-enter the good graces of the human family or the community that you had offended and that you had hurt, right? The state cannot facilitate our redemption, but it certainly can obstruct it or create an avenue for it to happen. Rachel, I don't know if you wanted to add to that part before we go on to the other reflections that Andrew had.
I think we're about out of time. Is that right, Sushma? Do we have a few more minutes? Or?
Sorry, I think we should aim to wrap up now. So I'll turn it over to you, Rachel, for any closing thoughts. I think this is something we could actually spend a few hours, maybe a few days, a lifetime unpacking. So this is just the beginning of the conversations and the journey, but we will be sure to also share with the audience your podcast link and the article link. So I'll turn it over to you, Rachel.
Thank you so much, Sushma. And thank you so much, Andrew, for your incredibly thought-provoking and thoughtful comments. I want to respond to your question about sort of this duality of organizing versus the lawyer's approach. And I think that there is a cheapening of the role of affected individuals and social movements to think that their only role is organizing on the street, that their only role can be in political change. Elites are certainly working with lawyers to develop legal meaning, and so why can't social movements do the same thing? That's sort of the nature of this project. It's not meant to sort of suggest that there is, and indeed, as you point out, the roads are closing in that direction in terms of courts, but we believe firmly that this is a fight that requires all of us. It requires being in the streets. It requires demonstration. It requires being here in Harrisburg in Pennsylvania for the state of Pennsylvania. But it also requires people like Ghani and I working together to develop legal meaning. It requires a strategy of lawyering that centers communities and lifts up the indigenous understandings of how the law affects them and how it should change. And that's really the nature of this project.
Here.
Well, I'd like to thank you all for joining us today, but especially Ghani, thank you so much for sharing your personal life story and your commitment to justice and redemption. And Rachel, for your incredible work stewarding this project along. It's such a privilege to work with you as a Carr Center Fellow. And Andrew, thank you so much. Looking forward to future collaborations with you while at the law school. Thank you all for joining us today. Look forward to seeing you soon.